Judgment in the matter of an application by Siobhan Mclaughlin for judicial review.
The question in this case is whether, when one parent dies, leaving young children, the other parent should be able to claim a social security benefit known as widowed parents' allowance, even though the parents were not married to one another. Widowed parents' allowance has been replaced by a different bereavement benefit for deaths taking place after March 2017. We are not concerned with the new benefit. Widowed parents' allowance was a benefit which depended upon the deceased having paid the required national insurance contributions. If there were qualifying children, the survivor was then entitled to the benefit, which was not means tested. But the survivor could only make a claim if he or she was married to or the civil partner of the deceased. Siobhan Mclaughlin and John Adams had lived together for 23 years. They were not married because Mr. Adams had promised his first wife that he would not remarry when she died. Ms. Mclaughlin and Mr. Adams had 4 children together, aged 19, 17, 13, and 11 years when Mr. Adams died. He had paid enough contributions for Ms. Mclaughlin to be able to claim widowed parents' allowance had they been married. Her claim was refused by the Northern Ireland Department of Communities, and she complained that the law was incompatible with her rights under the European Convention on Human Rights. Article 14 of the Convention prohibits discrimination in the enjoyment of the Convention rights on grounds such as birth or marital status, unless there is a good reason for this. Ms. Mclaughlin complained that the law discriminated against her and or her children in the enjoyment either of their right to respect for family life or of their entitlement to possessions in the shape of social security benefits. The European Court of Human Rights has held on more than one occasion that marriage is a special status, bringing with it rights and obligations between the parties which make it different from unmarried cohabitation. On the other hand, it has also held that there is hardly ever a good reason to discriminate between the children of married and unmarried parents. So was widowed parents' allowance principally for the benefit of the bereaved parent or principally for the benefit of the children? The majority of the Supreme Court justices hold that the purpose of the allowance is to benefit the children, and it makes no difference to them whether or not their parents were married. Lord Hodge disagrees and holds that the allowance is for the benefit of the survivor. Thus, in the view of the majority, married and unmarried parents are in an analogous situation for this purpose. But was there a good reason, a justification, for the difference in treatment? For there to be a good reason, the difference in treatment has to pursue a legitimate aim and be a proportionate way of achieving that aim. The promotion of marriage and civil partnership is a legitimate aim, and the allowance is one of a small package of social security measures which do privilege marriage and civil partnership. But denying the allowance in cases such as this was not a proportionate means of promoting marriage and civil partnership. The allowance exists because of the responsibilities which parents have for their children, and its purpose is to mitigate the financial loss caused to families with children by the death of a parent. This conclusion is reinforced by the international obligations which the United Kingdom has undertaken to safeguard children's rights, and it is noteworthy that in most of the other member states, survivors' allowances are paid directly to the children, irrespective of their birth status. This conclusion will not apply in every case where a surviving unmarried parent is denied the allowance. It will depend upon the relationship between the deceased and the children for whom the survivor is responsible. But where, as here, the deceased was father to the children, the relevant legislation is clearly incompatible with the Convention rights. The Court will therefore make a declaration to that effect. This means that Ms. Mclaughlin has won her case. But because the law in question is contained in an act of the United Kingdom Parliament, this decision does not change the law. It will be for Parliament to decide what to do about it. Thank you. The Court will now adjourn.